Why don't you skid my water, Mr. Velcro?
Between the proposed ADU in our backyard and the sewer main would not be required. The next day, he sent me a letter on October 4th affirming that the new utility connection between the proposed ADU and the sewer main at the street would not be required. On October 9th, Ventura Building and Safety Department approved the proposed ADU construction drawings. To be issued a building permit, I had to submit the sewer will serve letter. I could not get a will serve letter until I paid OVSD's fees or agreed to a deferred payment plan. So I paid the $947 fee, down payment, and signed a deferred agreement for the remaining $8,300. I asked Taylor in the front office at that point to note that I was paying under severe protest. And this is because OVSD is not requiring a new connection to the sewer main, therefore cannot charge connection and capacity fees for this ADU according to state law. Government Code Section 65852.2, subsection F Part 2, states that an ADU shall not be considered by a special district, sewer district, such as OVSD, to be a new residential use for purposes of calculating connection fees or capacity charges for utilities. Unless that ADU is constructed with a new single family dwelling. In that same section, Part 5, it states that connection capacity fees may be charged only if a new separate connection between the ADU and the sewer main is required. It states a local agency, special district, or water corporation may require new or separate utility connection directly between the accessory dwelling unit and the utility. And consistent with Section 66013, The new separate connection may be subject to connection capacity charges. Those charges would be proportional to the burden of the proposed ADU. But there's no direct connection required between the ADU and the sewer main, so no fees be levied. Further, in 66013, subsection B, part 5, provides a definition of fee. Fee means a fee for the physical facilities necessary to make a sewer connection, including the pipelines from the structure to the sewer main. The estimated reasonable cost of labor and materials for installation of those facilities. Additionally, Housing and Community Development Handbook, ADU handbook that they put out. Excuse me one second. The handbook describes how sewer districts shall not consider ADUs as new residential use for purposes of calculating connection fees and capacity charges, as I mentioned a moment ago. From their FAQ section, the question asked was, what types of fees are considered impact fees? They said in their answer, a local agency, special district like OVSD or water corporation shall not consider ADUs as a new residential use for the purposes of calculating connection fees or capacity charges for utilities, including water and sewer services. Only can be charged those fees when it's the construction of a new single-family home. Also, in the Housing and Community Development Technical Assistance Letter sent to OVSD in November 2020, almost 3 years ago, the letter states that if a new utility connection is mandated, then connection and capacity charges could be charged. OVSD, as I mentioned, is not requiring a new connection between the sewer main and my proposed ADU. Therefore, there's no connection or capacity fees that can be charged per state law on this ADU. And I'm not so naive to think that this board will vote to change its long-held practice of collecting fees, which now amount to well over $500,000. So I've requested an investigation from the Housing and Community Development Department into OVSD's practices. This is the right thing to do because the state law was enacted to construct more housing during an unprecedented housing crisis. Thank you. That's all I have to say.
Manager Jeff would like to present.
So I think I want to talk about a couple of things. Sort of a definition of connection and capacity charges, and then also what our ordinance does and how our ordinance relates to state law. Connection fees are traditionally imposed when an agency actually does some physical work or provides a physical component to do the connection. We don't have connection fees per se, but like a water district that provides a water meter and a meter box and wants the connection to their water line done in a certain way, will do that work themselves. And so they have a physical cost to provide that meter and that meter box and the copper pipe to the main out to the property. And they want to be in charge of that. They don't want contractors just doing that work in different sources. And so that's a traditional sort of connection fee to recoup those actual labor costs and those actual component parts that they provide. That way their meter and their meter boxes are all the same and identical to all of their other sources. The difference between a connection fee and a capacity charge is what's the capacity in the pipe. We charge a capacity charge where we look at the capacity of our pipe system to convey water to the plant and then process that water through the plant and meet the state treatment guidelines. And so a capacity charge is much like buying the capacity in the pipe. There's only a limited capacity in that pipe. There's only a limited amount of treatment capacity at the plant. And so it's kind of like buying and owning, that capacity, and each one of businesses and residences that are connected to our system buy and own certain capacity that they use for their uses. So, for instance, the Pepsi plant has 450 capacity units. The inn has about 200, and each individual house is one capacity unit. And so we charge a capacity fee based on the use of that in the pipe. So when the state started passing various housing laws that dealt with a whole host of issues, most of those issues related to land use decisions, how big they could be, setbacks, fire sprinklers, all sorts of things. But there is a section that talks about utility services and capacity and connection fees. And so the state makes a very clear distinction, state law, between an existing conversion of some sort and a new installation of an ADU. So there's broad rules about what is a conversion of an ADU. If you convert a garage, if you convert a barn, some of the local agencies have rules about converting a carport. I mean, it's a pretty broad definition, but it's really up to the land use agencies, the city in our case of Ojai, and the county of Ventura to decide if someone wants to install something, whether or not is a conversion or a new ADU. They make a very clear distinction about the difference. For a conversion unit, if you convert a garage into a housing unit, we're prohibited from charging any capacity charges or any kind of fees whatsoever, connection fees, mitigation fees. It's pretty clear in state law. But what also is defined in state law is that if you build a new ADU from the ground up, brand new structure, that you do get to charge, we do get to charge capacity charges, but they have to be proportional to either square footage or are they proportional to the number of fixture units or plumbing fixtures that are installed in that unit. The state gave deference to us as a special district to decide whether or not we wanted to use square footage or plumbing fixtures. And based on us being a water utility, we chose the selection of adopting a proportional fee based on plumbing fixtures. And so one capacity unit is 25 fixture units, and under the Uniform Plumbing Code, each plumbing fixture in a house has a certain number of points. So a sink and a toilet and a shower and all of those have different point values. You add them up, divide by 25, and you come up with a fraction. Most of the ADUs that we see are about a half of a capacity unit. And so we take that same ratio and charge and multiply that by our capacity charge and come up with the applicable fees. And so that's what we've done in this case. The applicant has proposed a new ADU. It is not a conversion ADU, as determined by the county of Ventura. And we did a plumbing fixture count based on their submitted plans and came up with the proportional calculation in accordance with our code. Our code was adopted in April of 2021 and was, after adoption, was sent to various advocacy groups and state HCD according to state law. The state laws that were passed required us to put together an ordinance, send it to them for their review. We've done that. That was done in April of 21. We have not heard from any agency, state or otherwise, recommending us to make any changes to our ordinance 82 or come up with any revised revisions or even explain what we did. So we've been operating since April of 2021 under the same set of ordinances that govern our approval of ADUs, how we come up with the calculations for our capacity charges. So that's sort of the rough background. We've gone through a very methodical process. We base our decisions based on the applications provided to us by the property owners. We base it on their plans, what they submit. And we do go back at the time of connection to our system, whatever that is, and just verify the plumbing fixture count. So if someone chooses to install less, then we will modify our fees accordingly, our proportional calculation. So it's actually based on the the plans are the starting point, but based on a constructed actual final product, we'll amend that if there's been any changes accordingly. So we go through that process and coordinate with them as they go through the design and so forth. We apply our code equally. If the county of Ventura or the city of Ojai says it's a conversion, we don't get into the definition difference between those agencies. It's really them as a land use agency to decide that decision. This applicant is providing and building a new structure from the ground up according to the county of Ventura. So that's the process we followed and how we came up with our code ordinance 82 in April of 21, and how we've applied, the appropriate fees accordingly.
Okay, thank you, Mr. Palmer. Would Christine perhaps like to answer any things that Jeff might have brought up?
Yeah, first, I think you should start with the law, looking at that first, when you're doing your evaluation of ADUs. But I'd like to bring your attention to page 2 of the HCD's letter from November 2020. I have a copy here if anybody needs it. Second paragraph on page 2 talks about detached new ADUs. And in that, they specifically say new utility connection directly between the ADU and the utility may be mandated. And if such a connection is mandated, then a fee or charge may be imposed. It goes on to say about the fee or charge should be reasonable. But the main thing is it says if such a connection is mandated between the ADU and the main, then a fee can be charged. It is very clear. I have a copy if anybody would like to see it, underlined and highlighted the important information. That's all.
Randy, the question about process.
We're moving closely to that section. Right now, we're going to ask Jeff if he would like to clarify anything that he said earlier.
I don't think so. I think the state law is very clear. They draw two distinctions, two different types of ADUs. Our code was adopted and provided to HCD specifically for them to review and approve. They accepted our ordinance as a valid ordinance at the time. So we've continued to apply that based on our code over the years since we adopted ordinance 82 in April of 21.
Thank you very much. Now, the directors may address either the public or the manager at your choosing.
We ask our attorney question.
Yes, you may.
So as I listen to this, Jeff just said there's two circumstances. I read it, or I see three circumstances. One is, as Jeff mentioned, ADU that's either part of an existing, of a bedroom, something like that. In case the sewer line goes from the existing building, added some stuff to it, straight to the sewer line. The second case is if a freestanding structure is created as an ADU and it's mandated that we run a line from that freestanding structure through the main sewer line, that is subject to these fees. Charges. But the third option is, I think Colin's proposing, is that the line actually comes from the freestanding structure. It does not go to our main line. It goes to their existing line from the original house to the street. As I read this stuff, those are the three options. I don't know your responses to that. I see it that way reading it. I don't know why we wouldn't have considered that ordinance back in 20. What is your thinking on that?
My thinking on that is that is a question for Jeff to answer, because that's a question about his position on the ordinance itself. If it gets to what does the ordinance itself say, I can obviously guide you through that. And that's found in section 301.4, the application of capacity charges. And there, that section, both sections A, B, and C follow the allowance for capacity charges for ADUs of a particular type pursuant to Government Code Section 65852.2. So that section of the OVSD code section, which was adopted by Ordinance 82, follows precisely what 65852 allows. And so that's what it says there. And the situation that you're raising is, given where the connection is, does that change the way that this ordinance applies? I think that's more of a general manager question. So if you're looking at straight from the ADU to the main line, or the ADU to the lateral that the main existing structure has, that's the distinction. And I think that's something that Jeff is more than capable of responding to.
And here's my question, Jeff. Let's just say, hypothetically, even though it's very closely aligned with reality, is that we came up with an ordinance as a board, voted and approved, we thought we were doing it right. Now we look at it and say, well, you know, there's perhaps another circumstances that we can include in our, or contemplate in our ordinance. So while when you hear appeal to a decision, or here's one, you kind of have to go with what our ordinance says. You can't on your own say, well, our ordinance doesn't match the law, so I'm going to rule some other way. You have to think, follow what the district's ordinances say, which I believe you did.
That's correct.
I'm saying, it appears to me that the situation this, or is being proposed, wasn't contemplated in our ordinance, but was contemplated in state law. So at least that's what it appears like to me.
Well, I think this raises the question of sort of the ordinance development process we went through to develop the ordinance. And I think you are correct. When we apply an ordinance, when we apply something to something today, we look at our ordinances in our code, whether it's a spill or any kind of permit issue, we look at our code. The question you're asking goes back to the development of the ordinance in the early 2021. I contend that an ADU will be connected to our system somehow. And that connection may go one of two ways. It may go to the house and then to the street. It may go to the street separately. There are situations where we've had, based on topography, where an ADU placement on a lot can't get to the house. And so it goes to the street through, you know, a separate pipe because of topography and so forth. But in either case, the ADU will connect to our system. We believe that when we developed our ordinance, that the connection, however it went, to the house and into the street or to the street directly, could be subject to a capacity charge. That state law didn't say, we don't believe, that if you go to the house first and then to the street, you're exempt from all fees, even if you build a new unit. We don't believe that. That's not the ordinance. That's not the discussions we had at the time the ordinance was developed. That's not the discussions we had when we made the distinction over two types of ADUs. We didn't say there's three types of ADUs. We didn't go into the pipe alignment because the pipe alignment is dictated more by the topography of the land and the placement of the ADU on the land itself, not necessarily what we would dictate and how we would dictate the piping to go. If someone connects an ADU to a house and then to the street, our question would be, is there capacity in that pipe to carry the flow? You know, it's an engineering question. Can the pipe flow get out to the street because of topography? And so we didn't make the distinction over the piping. We made the distinction over the two types of ADUs. Is it new or is it existing as determined by a land use agency? If it's new, we would apply the rules the state applied, which was we're going to make it proportional based on fixture units rather than square footage. Those are that's how our ordinance was developed. And that's how the clear process was to develop our ordinance compliance with state law.
I was very much involved in developing that, but it strikes me that discussion around whether a new main line is mandated or not could be dictated by engineering considerations, such as topography, on a cliff, but still on the same lot, all the things that you can imagine in your own mind as to what those might be. But it appears to me that the state law considers that, making the statement, if it's mandated, you can charge the fees. Which by itself says, it implies that if it's not mandated, there's a counter to that.
Well, I think
So what I'm thinking in my own mind right now as I read this is we did not contemplate the pipe connections, as you said, but I think maybe this instance could show that maybe we should have.
well, I think it's two different sentences. I think the sentence says you may require a new connection or not. But there's a connection either way. Then the second sentence is the connection may be subject to capacity charges. Now, if we required a separate connection for an ADU, the cost of that connection would be exorbitant. By the time you grade across a lot, you get an encroachment permit from the city or the county to cut the street, you dig a trench across the street, you do a hot tap into the main line, you're talking about tens of thousands of dollars just to have that separate pipe. I don't think that's reasonable. Just require second pipes, just for the purpose of requiring second pipes, if there is an appropriate system that can work. In certain situations, based on the land, gravity wouldn't work. And so I think there's been a couple, less than a handful of, we've processed probably 150 plus ADUs in the last 5 to 7 years. Vast majority of them have been conversions. And the vast majority of them, I think less than one hand, have been able to use existing piping to make the connections. They can't, they can. If they can, they can. But I think the state law is two different sentences. It's,
Well, it is, I agree with you. Your statement is two different sentences, but what's within the sentence is what's important. What it says, connection directly between the ADU and the utility. Doesn't say indirectly, which means ADU to existing line into utility. It says directly between the ADU and the utility. If such a connection directly between the ADU and the utility is mandated, then a fee charges may be imposed.
it doesn't, there's not an if there. It's two different questions.
There is an if there. It says right there, if.
Because
If such a connection is mandated. Connection
Paragraph-
is directly to the ADU and the utility. Here's where I'm ultimately going with these questions. Ella has suggested that she's asked some other agency as to review stuff.
Sure.
I don't have any problem with that. What I'm wondering is, in my own mind, is should we put this aside until those discussions are had with that other group and this issue of the third possibility is resolved?
that's a board decision.
Yeah, because that, if it were me, aside from issues they may have about timing of construction, I would want to have that clarity either from our attorneys or from whatever group wrote this letter or whoever it is she's approached. But in my mind, there's very clearly a difference between like I said, in my mind, there's 3 different possibilities. Doesn't appear to me, from what I remember, we considered this third possibility drafted and ultimately approved that ordinance. So anyway, I'm done. That's just what I was thinking.
This
So
is question and answer, but would our legal counsel like to comment on
There's a couple of things I'd like to add or try to explain on this issues that Director Martinson raised in regards to the government code section in particular. But I'd like to work backwards on your last statement about the investigation statement that was made by the appellant about the housing and community development investigation. This also plays into a statement made by your general manager that when Ordinance 82 was adopted, HCD was given notice of every single board hearing where that was done. They were given copies and drafts of each one of the Ordinance 82 review. They were given an opportunity to comment on them, to say whether or not they believed that we were on the wrong side of the law or on the right side of the law. They did not comment at any time. There were conversations between the general manager and HCD staff about Ordinance 82. I was a part of those conversations. Their legal counsel was on the call regarding Ordinance 82. We asked them specifically, do you have a problem with this? Are you going to take any action? They said no. We gave them more time to consult with the Attorney General's office. They did that. Heard nothing back from the Attorney General's office. So they had every opportunity to say something about Ordinance 82 being outside or contrary to the existing government code section, and they did not do so. So on that basis alone, delaying your action on this one would two things. I think it does justice to the appellant here. One came here for a decision right now about an up or down vote, and that's in your package. So I don't think delaying this matter is going to give the respect that the appellant is seeking for your board to make a decision. Number two, HCD simply doesn't have the legal jurisdiction over this agency. It does not. They do not have, by law, any enforcement capability over this agency about how it does that. As a matter of fact, the only way to enforce this matter is through the existing Code of Civil Procedure through a private action. And I'm not going to get into details about a private action against this agency, but those things can be done and people know how to do that. So that's the way that the statute is enforced. It's not enforced via state agencies such as HCD, whose primary purpose is to increase the housing stock in the state of California. As the appellant has already indicated, there's a housing crisis in California. So that's really their main charge. It's not really to determine whether or not an agency like OVSD has complied with 65852.2. Really, their charge is to see as many housing units developed as much as possible. So for all those reasons, I think a delay would be something that I would recommend against. Secondly, with regards to the code section here, second sentence, 65852, subdivision F, paragraph 5 says, consistent with section 66013, the connection may be subject to a connection fee or a capacity fee. Notice the distinction, it's a disjunctive. It could be either or, right? That shall be proportionate to the burden of the proposed accessory dwelling unit based on either square foot or the number of drainage units. As the general manager was trying to explain here, and I think he did a good job doing that, if there is a burden on the system that you're charged with taking care of, is the Ojai Valley sanitary sewer system, collecting the waste and then processing it for discharge into the Ventura River. That is the system. Anything that burdens that system allows this agency to charge a fee for that burdening on the system that is proportionate to the burden on it. So that's pure and simple. So by going to the second sentence in 65852.2 F5, you get exactly what has happened here. And this goes to what the general manager was saying. One way or another, it's going to connect to the system, via the main house or by itself. And that is a burden on the system. And 66013 says you can charge a fee for that.
If it's a new and separate.
In saying that, we also know that auxiliary use, we cannot charge connection fees, also impose burden on the system.
True.
So in that case, we're not allowed to charge them. which implies there may be other instances where we're not allowed to charge, even though it's a burden on the system. So I don't think it's quite as, in the two-case model, it's cut and dried, in my opinion. That's very simple to understand, and that's the way it is. I don't have any problem. It's this third case that I think is a nuance that I don't think we addressed in our ordinance.
Can I just say one thing about your statement that there are auxiliary units that are exempted from this because they're burdening the system, right? I get that. They're small units or they're units that are converted and they're burdening the system, but yet they're given a free charge. That's the statute. That's the legislative authority. The legislature can do that, and it's signed by law. Once it's signed by law, it doesn't give the special district the ability then to say, that's an implication that there are other things out there that I can sweep into this category of exempt sources. There is no such implication, nor is there an allowance by a special district to infer that based on the statute. So I want to be very careful about how we read the statute here.
I see what you're saying, but this also says very clearly that unless it's a new line, you can't charge. I mean, that says that right in there. It's very clear.
Okay,
And I can understand, if I came in wanting to do an ADU, I can understand, having read that versus our ordinance, that there's a mismatch. And so I would want to know, who's the authority to resolve the mismatch? That's what
The authority,
really going, I don't know.
authority is with you. It's with your board right now. Okay, and so secondly, I'm going to the appellant's statement, which is in Exhibit 19. And if you look at Exhibit 19 and you compare stations that she places in her November 13, 2023 email to Allison Young, she appears to quote code section 66013 as well as 65852.2. And there is the inclusion in that section of a couple of statements that are not necessarily found in the statute itself. So again, in 65852.2, it cites subsection F, part 5. She goes on and highlights it, uses ellipses. Then in the second sentence, she adds the words in a bracket. Bracketing a comment is adding language to the statute. Those words new/separate are not in the statute. And I think that's very important to see that. All right. So how we write and how we copy statutes, you're inserting language that doesn't exist in the statute. And that's called extra legislative language that the legislature hasn't seen, the governor hasn't signed into law, and we have no ability or authority to add to the statute. So be careful when you read that there, because it doesn't exist as she's put it in there. So just want to draw your attention to that. And that, again, doesn't give you the ability or authority to infer that there are other situations that the statute doesn't apply to. What I'm saying to you, and going back to 66013, is that by commenting on the capacity and the burdening of the system, it allows an agency such as OVSD to then charge a capacity fee.
Director Kintosh, would you like to ask questions?
Just as a procedural matter, it's not that we're deliberating now. I think we're on item.
We're actually questioning.
We're supposed to be asking questions of the general manager and Ms. Price. We're not supposed to be.
Or the
debating
board
the
of
issue.
council.
Or council.
It's questions.
One, I believe, it's my belief that the applicant has misunderstood the state law, and I wanted to try and present some alternate explanation, an alternate interpretation of state law. And I just don't know at what point does that fit into this process.
If I could add clarity to that.
Yes.
Why don't we just finish the round of questioning and then allow Director Kantosh to make a statement? Because I think it goes more to deliberation and decision-making than it does to responding to a question. That would be my recommendation. So I appreciate that. Yes, sir.
Okay. Hardly ever patient.
when I ask a question. This is a question for Mr. Kwong. It seems to me, as I read all of this, that I was reading something I had read almost identical to this very recently. It seems to me that we have had a case and an appeal, subsequent litigation, exactly this same issue. Am I correct in that?
You are correct, Director Quilisi.
Okay. And the decision of the court was that
And that,
the decision, I should be very specific in my language. The court did not uphold the suit or the litigation instituted by another party on exactly this same issue.
that's correct.
Okay, so that the court in effect found that the district, regardless of the type of connection, is legally allowed to charge a capacity fee separate eventually from a connection fee. That,
That's correct.
okay, very good. Thank you.
Are there any other director questions to the general manager or the appellant? I have one for Jeff. The way we formed the connection fee looked like it was comprised of 3 or 4 different assets, including the collection system and the water treatment plant. Is part of that the distance to the?
So when we developed our capacity charge and we did our capacity charge studies, we acknowledged that there are different components of our system to get the water from an individual house all the way to the treatment plant and through the treatment plant. It's not one fee, it's actually 3 fees. It's a local charge for small diameter pipe that gets the flow out of a neighborhood. It's the trunk line, which gets the flow sort of from all the neighborhoods down to the plant. And then the third piece is the flow through the plant. The plant has, each pipe has a given hydraulic capacity. It's based on the size of the pipe, the slope of the pipe, how steep the pipe is, and how slick the inside of the pipe is. I mean, it's a standard hydraulic sort of calculation for clay pipe or plastic pipe. So we went through and said, here's the component of our capacity charge that gets the flow out of a neighborhood. Here's the charge that gets it down to the plant, and here's the capacity through the plant for that water based on typical pollutant loads. And so it's actually 3 fees. It's actually not a singular just sort of number. It's based on those 3 systems and the value of the systems that exist and the capacity of those systems. We have some areas of our system where they're at a higher usage of capacity than others. So every time someone connects to our system, we look sort of where they are and where they're going, and how we're going to make sure that the water can stay in the pipe. And so that capacity charge sort of takes into account those 3 components.
Jeff, another question. I'm looking at the ordinance that OVSD formulated. You said it was 2021.
Correct.
And I see on page 7 that definitions of the word sewer connection, and capacity charge. And this document was submitted, someone said, I think our legal counsel, submitted to HCD for approval. According to their handbook, page 27 is required. So we did submit that to HCD for approval.
Yes. Yes. So the actual state law not only specified all of the components of the law, but also specifically had 2 sections in it at the bottom of the sort of the narrative that required that we do an ordinance, that required that we send it to them for approval, and laid out a process for if they had corrections, that we had a certain amount, a very limited amount of time to make any corrections that they required of us to make. And so those are actually written into the state law that says, look, here's the law, comply with it. And after you've complied with it, send us what you're doing so that we can check your work. We did all of that. We sent it to them in April of 2021, and they did not have any comments or changes or recommended modifications to our ordinance. We didn't have to do any follow-up work because they didn't respond to it. We also sent it to some advocacy groups. They also didn't respond with any corrective actions or notification letters to requiring us or suggesting to us that we change our ordinance.
Okay, thank you. And should the appellant, I have one question. After you executed the agreement signed for the deferred payment, I guess it's a 5-year plan. You, at some point, you decided to appeal that. But you did get a permit from the county, is that correct? For occupancy?
I paid the fees to OVSD that I was required to pay in order to get a will serve letter. If I had that will serve letter, I submitted it to the county. And get a permit without that will serve letter.
So the will serve letter was given to you once you agreed to the stipulation that 5 years of payments with no interest.
Yes, once I paid, that was released to me.
Is the ADU currently occupied?
Not even built yet. We just got the.
Oh, I'm sorry.
October.
I thought this was a delay that we were causing. Any other director questions of the appellant or general manager? Kentosh, did you have something additional?
I don't have any questions, but as part of the, have some information I would.
This will be a good time.
Have to close the public hearing and then we deliberate.
I think he's right. I think
Mr. Bond,
Yeah, you close the public hearing. If there's no more questions, and if the general manager and the appellant don't have anything additional to say, then you would close the public hearing, and it's just you.
well, at this time, if there are no additional questions, we will close the public hearing at 6:55 PM and enter the deliberation portion where the board of directors will deliberate on the action at hand. We have option 1. These are our choices as directors. Option 1, affirm the general manager's October 3rd position of capacity fees on the basis of applicable law and the facts. Or option 2, reverse the general manager's October 3rd and that the imposition of capacity fees was justified on the basis of application, law, and the facts. So with that in mind, let's have director opinions, discussion on that subject. Mr. Kentosh.
I think the way this is supposed to work is we're supposed to be like an impartial panel. We're not supposed to be involved in the actual discussion, the presentations and the arguments and that kind of stuff. We listen to the arguments and then we just deliberate independently. I'd also like to point out, Lowell, you were reading, when you weren't actually reading from the state law, you were reading from a letter from the ADU, from the HCP.
I know that.
They're be very careful because sometimes they throw their own interpretation into things too. So
But I had read it higher up above, so I knew.
So it's a very complex issue, so I'm going to read from my notes. I've spent a lot of time studying this and I like to put my thoughts. My approach differs somewhat from that of Mr. Palmer. He focuses on the correctness of our ordinance 82 and bases his determination on that, but instead prefer to respond directly to the assertions made by the applicant. The applicants state their case in an email from Ms. Price dated November 13, 2023. They make 4 major arguments which are concise and clearly stated. I would like to respond to each of their arguments. Number 1, applicants claim the government code 65.852.2 F5 states that connection and capacity fees may be charged only if a new separate connection between the ADU and the sewer main is required. But is that really what the law says? By the way, these laws are written in very complex language. I mean, it takes a lot of staring at and scratching your head to try and figure them out. Let me tell you what I think. For me, the answer to what the law says is provided in the two sentences in that section of the government code, which applies for a standalone ADU. Mr. Palmer alluded to those two sentences, and Ms. Price read parts of them out the meeting. First of these two relevant sentences, everything boils down to those two sentences, in my mind. First of these two relevant sentences includes the words, a special district may require a new or separate utility connection directly between the accessory dwelling unit. The sentence says nothing about connection fees. Its purpose is to allow utilities to require a separate utility connection. So it just allows us to require a separate connection. The implication is that there are several types of connections. New connections, old connections, separate connections, or combined connections. All of these are connections to a utility. Next sentence of the code, Jason, immediately afterwards, covers a different topic and includes the words, connection may be subject to a connection fee or capacity charge that shall be proportionate to the burden of the proposed ADU. This sentence doesn't say what type of connection is subject to a connection fee. Its wording does not limit fees or charges only to separate connections. Without any clear limitation, the wording must be applicable to any utility connection, whether through a new lateral, through an existing lateral. To apply part of the wording from one sentence merely allows utilities to require separate utility connections. As a limit on connection fees in the next sentence makes no sense. Installing a separate connection does not change the burden of the ADU on the sewer mains and treatment plant. Please note in their email, the applicant cited these two sentences, added two words in square brackets to this second sentence, and changed the to that as follows. The new / separate connection may be subject to a connection fee or capacity charge. Note that the words new and separate are not found in the actual law. There's nothing nefarious here. The use of square brackets is a clear indication that something they're trying to hide anything. Nevertheless, in trying to attempt to clarify and to add those words to better conform to their understanding, my reading of the law does not require the additional word. Furthermore, the applicant's interpretation is outside the law interpretation. Furthermore, the applicant's interpretation would place an unfair burden on the rest of the district's customers who would be compelled to subsidize wastewater treatment capacity in ADUs. So, sum up, with all respect, I think the applicant has misunderstood the state law by holding the interpretation or something that's said in one sentence and applying that to the second sentence. I don't think the law was intended. So it's a matter of interpretation. That's just my interpretation. I may not be right, but I'm perfectly happy to have HCP take a look at it, and I'm happy to see what they say about it as well. So that was the first point they made in their letter. The rest of them are a lot briefer. The second point the applicants make in their email is the cited definition of fee given in section 6601.13. Argument seems to be that connection fees are limited to the cost of hooking up, or that does not limit the capacity charges that are the primary issue here. So I find that's really a urgent concern. Second point. Third point they make, the appellant's third argument, now this one is very relevant. The applicant's third argument cites an HCD handbook stating that a special district shall not consider ADUs as a new residential use for the purpose of calculating connection fees or capacity charges. And by the way, that statement is straight out of the California law, an earlier section of the California law, so they're just repeating what the law says. So the law, let me just try and sum up that one more. Local district shall not consider ADUs as a new residential use for the purpose of calculating connection fees or capacity charges. Here's what HCD's November 23rd, 2020 letter says about that. The law. It says, the effect of these two provisions is that the district may not treat an ADU the same as it would a single-family home and charge the same fee. So that's how HCD interprets that provision of law, which favors our interpretation. That is why we revised our ordinance in 1920. ADUs are now, as Jeff has mentioned, ADUs are now treated differently than a single residence. Well, the appellant's fourth argument is similar to the first argument, cites the HCD letter. As if such a connection is mandated, the fee or charge may be imposed, but it shall not exceed, etc. So nothing in this sentence prohibits capacity charges. A separate connection is not mandated. Anybody's ever taken a course in logic in college? What's happening, what would, if I try and botch up interpretation of the logical application of this, is that the applicant is trying to replace an if-then statement, an only if-then statement. If A, then B is not the same as only if A, then B. So it's kind of that's kind of an obscure reference there. So I hope the applicant will please consider that there might be a second alternative interpretation of the state law. I hope I don't sound harsh, so I yield the floor to further deliberation.
Thank you, Quincy. Any?
Not a lot, other than to say, Ken Tosh and I have spent a lot of time, I think, reading government documents in the past. And in particular, notice the appellant, both in email and in oral argument tonight, referring several times to the HCD letter in November of 2020. Our ordinance in spring of 2021, I think, was a direct response to that letter. And from what I can tell, HCD has not said we have misinterpreted anything that they said. Second, I think it's important here that we again show that there is a difference between a connection fee and a capacity charge. And looking across multitude of housing law changes, and particularly ADU law changes, my understanding, and I would ask Mr. Kwong to tell me if I have misunderstood, the law as it stands right now is that district is allowed to charge a capacity fee for an ADU unless it is otherwise prohibited by law. And it is specifically prohibited by law if that ADU is a result of a conversion of an existing structure. But absent that, district is allowed by law to charge a capacity fee, whether or not it charges a connection fee. And at that point, I think, and as a result of subsequent litigation on exactly that point, I think the district's ordinance is correct as it stands. The inclination is to deny the appeal.
Any other director comments? Director Stone? Okay.
No, my question's answered.
So it's upon the board now to make a motion, option 1 or option 2, according to our agenda, to affirm an option, a motion to affirm general manager's ruling or deny the general manager's ruling. We're not going home until there's a.
Oh, I do have a question because there are points 3 and 4 follow. Issue a notice of decision, inform the property owner and appellant. And so I guess we need to vote on option 1 or option 2. And then we need a subsequent motion to deal with 3 and 4.
Proper.
Well, I will move approval of option 1.
Second.
Okay, we have a motion for approval for approval of option 1 in our agenda, which affirms the general manager's October 3rd ruling. We have a second.
We need 4 votes for this.
I think it's majority.
We need a majority of directors present and voting.
Well, we only need 3 of it because there's 5 of us here. Need 3. I'm just curious.
Okay, Allison, would you please take roll?
Director Kentosh,
That's,
Director Martinson,
I don't think there's any option but to approve what Jeff did because he did it in accordance with our ordinance. So I vote to hold his.
Director Stone,
Yes.
Director Quillisi,
Yes.
and Chair Berg.
Yes. So now we will consider items 3 and 4. Issue a notice of decision within the time period set forth in section 917. Item 4, inform property owner appellant of his or her rights under section 917.6.
I move approval of sections 3 and 4.
second.
All right. Motion and a second for approval of items 3 and 4 of this motion. Allison, please take roll.
Director Kentosh,
Yes.
Director Martinson,
Yes.
Director Stone,
Yes.
Director Quillisi,
Yes.
Chair Berg.
Yes. Okay, at this point, I believe we have completed public hearing and the deliberation. And this is item 9, and we are
We're done.
thank you very much.
Let's thank everybody for coming today and there's a real problem with homeless and housing crisis. Housing crisis is the reason my son lives in my house.
Okay, we will now move on to item 10 on the agenda, which is our fiscal year budget, income and expense reconciliation, and budget adjustment number 2024-08. Yeah,
This is something we do sort of in the fall of each year, back at our previous fiscal year, closing on June 30th. We look at how our revenue projections came out versus what we projected. And we also look at our expenses compared to what was projected. And then we make adjustments because of, any overages. The good news is, everybody's hard work has made sure our expenses come in under budget. And we're fortunate in that our revenue comes in over budget. So there's extra money coming in and less money going out. The net is $924,000. I think there's some discussion about this because of some recent sort of conditions. We try and budget very conservatively. We don't make overly overestimates of revenue and rely on them. And we don't budget extra money in our expenditure accounts just as sort of a slush fund. It's just not an appropriate sort of approach to budgeting and having discussions about dollars we spend and where those dollars come from. We were notified today that DFA, Dairy Farmers of America, has ceased operation. They have laid off their staff effective the end of January, closed their facility at the Pepsi plant. We'll be closing our facility. That's our single largest revenue producer. And frequently, because they were running really hard, they would run 2 or 3 crews and they would over discharge flows to us based on their 450 owned capacity units and pay extra surcharges and fines and penalties for exceeding their allocation. That amount of money we've never budgeted, but we knew it was always there and it was coming in on a regular basis. Well, that's going to cease to exist. So yes, this year, closing June 30th, they were running really hard and generated more revenue than we estimated. We think it's a conservative approach to not include that overage as a assumed guaranteed cost. And lo and behold, just today, we were notified that they're closing and ceasing operations. So the good news is there's extra money from their operations last fiscal year, and there's extra money for their operations through current. But going forward, there's some revenue, some extra revenue that won't come our way going forward. They sort of purpose that plant. Now, the dollars don't go to zero because they own those capacity units and they pay a capacity maintenance fee. That's usually what we budget for the fact that they own those capacity units and they have to pay for them whether they discharge or not. We just don't budget for the overage. And so things are going to tighten up a little bit going forward. We're going to have to get smart in our next year's budget to make sure that we don't have that little extra cushion that we've had in the past. What's before you today is basically to take all that overage and assign it to the collection system reserve, put it into the collection system, and bank that money for future collection system projects or other needs that board may decide are an appropriate use of those reserve funds going forward. So we're recommending that we take all of that, we put in the collection system reserve. But going forward, we're also going to have to be smart about how we spend money. We don't have that extra cushion that we've had in the past.
450 times $58.
Yes, a month. Now, this isn't uncommon that facilities aren't in use and are still paying a fee. The bowling alley, the east end of town, has a few capacity units, I think 3 or 4, if I recall correctly. And they've been paying on them for 25 years because the facilities there, the buildings there, it could, if the land use approvals were there, it could start operation as something else tomorrow. And so they pay what we call a standby fee, and they pay 75% of the $58 because they're not being used. But they pay that 75%, the 58, month in, month out, year after year after year, now going on 25 plus years. And so Pepsi DFA will still have to pay some proportion of their fees. They just won't pay 100%, and they won't pay that overages that is a big chunk of some of our revenue enhancements that we've seen over the past years. So the good news is there's been extra money. The sort of cautionary news is we don't have that extra cushion that we had going forward.
Dr. Stone.
Yeah. It's it slipped my mind because we've discussed it so many times in the past. Is Petrogym still paying?
No.
So they don't have,
Well,
they haven't sold back their.
yeah, yes, they're paying. They haven't sold back their capacity, all of their capacity units. When they closed years ago, they sold a big chunk of them back, and they've maintained, I'm guessing, I think I saw they have like 10 that they retained as part of that closure of that facility. They had more, and they sold most of them back, and they retained a few. And they would be under the same sort of condition. They pay that 75%. There's been some talk of redeveloping Petrochem into sort of an industrial manufacturing sort of business park. And those buildings, although they're usually fairly large with a lot of square footage, their plumbing load is pretty small because they usually have just an office or a small mezzanine sort of use and a large warehouse space. So I think if they had, a few up to 10 capacity units, that's probably enough to do the majority of what they would consider redevelopment if they could get those approvals through the county.
Any of the director comments or questions? I'd like to entertain a motion. This is a budget adjustment.
Approved. That's your adjustment.
Thank you very much.
I'll second.
Excuse me. We have a motion and a second. Any further discussion on this item? Allison, please take roll.
Director Kentush,
Yes.
Martinson.
Yes.
Director Stone.
Yes.
Director Swasey.
Yes.
And Chair Berg.
Just for grins, I multiplied 75% times $58 times 450 capacity units. It's just under $20,000
A month.
a month.
We budget, I think, just over about $300,000 in revenue from them per year for use. It would be a little bit less than that based on the 75%. They bought those units many, many years ago. So if they sold them back, they would not be selling them back at the 16,000 number today, but they could sell some of them back, but they can only sell them for their original purchase price, which were many, many years ago.
Okay, we're moving now to item 11. This is the replacement of gap vacs. Is it Hybon?
Yeah.
Vacuum positive replacement blower. Budget adjustment number 2024-09.
So our gap vac is a combo truck. It has a hose system to clean main lines, and it also includes a vacuum unit to vacuum out manholes. There's a large vacuum pump on the truck. When engaged, can lift the debris and leaves and even water out of the manholes. The guys were doing a inspection on the vehicle and noticed an oil leak out of the bottom of the truck. Did some diagnosis of it and determined that seals and the system, the lower pump, had failed and was leaking out the bottom. Obviously, this is a real critical need to have the truck, so they went to the manufacturer and got two prices. One, to put in a new blower unit, or two, to take our blower unit out, send it out for rebuild, and then reinstall it. The rebuild actually is more expensive because of the length of time to take it out, send it out for rebuild, and come back, and the need to have a replacement rental, a substitute unit in place for us because we have to be able to respond to emergencies and spills. So normally you'd say the rebuild is cheaper, but the rebuild is a longer process and the rental unit is more substantial. So that's where the cost went up. The new unit, it's just to take one out, put a new one in. Yes, they provided a rental to us, but they provided the rental for a much shorter period at no cost to us. So we get a shorter turnaround and we get a free rental versus a longer turnaround and a charge rental. This is actually a confirming action because of the emergency of the situation. Go ahead and do it because we need the vehicle. Time to sort of wait and figure out how to deal with it. So our truck is already down at the manufacturer and they're taking out the old unit and installing a new one. And hopefully here within the next week or so, we'll be able to get our replacement truck back and swap the rental. Since it's a one-for-one swap, one of our guys, I think Dwight, got the honors to drive our truck down and drive the rental. And I'm not sure if he gets the short straw and gets to drive the rental down and our truck back, or the guys are gonna with some other system. But it's an all-day thing to drive down and back, given the traffic in the LA basin these days with the 10 freeway closed. So yes, it's a burden to go down and back, but at least we have an operating unit here full time.
This is a no. It's the pleasure of the board.
New blower is more expensive than the rebuilt blower, which is what you'd expect, but the other stuff makes the new unit a better deal. I would move of item 11.
Second.
Okay, we have a motion and a second for approval. Any further discussion on item 11? Allison, please take roll.
Director Kentosh,
Yes.
Director Martinson,
Yes.
Director Stone,
Yes.
Director Fossey,
Yes.
Chair Berg.
Yes. Okay, moving on to item 12A, B. Replacement of wiring to power and control of the middle aerobic mixer, including excavation and installation of above ground conduit and replacement of existing eroded wiring. Total cost of $56,250. Budget adjustment number 2024-10.
So when we did the plant upgrade in the 96 timeframe, built all the new tanks and motors and everything, they put the conduit for all of those. It's underground. So we have these motor control centers where the power comes in and goes through a series of breakers and then goes out underground, goes out to all the different motors. And then all the control wires come back into that same motor control center and goes into our SCADA system. And there's dozens and dozens and dozens of wires going all over the plant. The trade-off when they built it new was they put all of those conduits underground and in the concrete structures. And so you get a cleaner sort of finished product. The downside of it is if any water gets in any of those conduits or any sort of corrosion occurs or those conduits gets pinched or something over time, now you've got a wire in a wet environment, maybe pinched, and fortunately we've had a series of over time shorts and wires that have failed in this varied but very clean looking system. Sometimes we're able to sort of pull out the wires and put in new wires because it's not a bad a pinch or a corrosion as others. And occasionally we've had a couple have to redo a conduit, but I've had the ability to sort of do it simply. This situation is one where the conduit's underground for a ways, and then it's in a large duct, large vault underground, and then it goes from there out to the aerobic digesters, and it's that from that vault out to the actual motors that we have the pinch. There's no way to sort of figure out exactly what the path of travel of that conduit. If we knew exactly how that conduit got from that vault to the motor, we might be able to do something. But you know, the conduit goes underground, it gets in the concrete structure, it's in the walls, it's in the deck. We don't know exactly how it gets from point A to point B, but we know somewhere between point A and point B, there's a problem. The wire corroded, water got in, and we lost power to that motor. What happens is you start getting intermittent sort of things. These things don't just usually fail instantaneously. They sort of over time degrade. And so the guys go, you know they have a problem, but then it's back on, and then it goes for a while, and then it fails, or it. And so by the time you figure out exactly where the problem is, you can maybe try and fix it, but in this case, you can't. They tried to snake the conduit from both ends and figure out where the pinch is, but it's going through so many curves that you can't figure out exactly where the problem is. The solution, unfortunately, is to sort of come out of that vault, the ground, over to the edge of the ditch, and then surface mount a new conduit from point A to point B and repull the wires. That's what's before you today. It's two pieces: somebody to come in and dig the trench, and an electrician to come in and put in all the conduit. Anytime we get in a situation like this, we also put in a spare conduit because, once you got the trench open, one more conduit that's empty to allow the flexibility for the guys to do something else in the future is money well spent. So unfortunately, we have a situation where the way it was constructed led to a fault, led to a failure, and there's not an easy fix. And so we're gonna sort of do a modified fix, put in an extra conduit. And this includes the digging and the electrical and all the work to reconnect all the systems back up.
Sounds like part of the problem was good as-built drawings from 96.
Yeah, you know, the conventional sort of wisdom in plans is they place the vaults where they need to go. Then they take a little arrow and they put a number by it. They do a short little arrow with an arrowhead and they say, you know, conduit 47 goes that way. And then on the other end, they have a dot and a little arrow and it says conduit 47 goes that way. And where it goes actually between A and B is sometimes a mystery.
We'll do it differently this time.
Well, with our new project, everything is external and surface mounted. And bury any conduit. So yes, it's not as clean. Yes, it's not as pretty. Yes, it's not as sort of sleek. But you know what? If there's a problem, figure it out exactly where it is. And unfortunately, these things don't show up as problems normally a year or two down the road. It's 20 or 30 years down the road and stuck. So our new project, we just surface mounted everything and we labeled it. And in 20 or 30 years, if God forbid something happens in one of those conduits, well, you can pull it apart and blow it out and reseal it and re-pull the wires, and you know exactly where you're going. The old stuff is sometimes difficult to figure out.
We had this exact problem in the oil field down here. We had pipelines that were buried, no idea from A to B where it went. When they had the fire that one Thanksgiving, all of a sudden we saw these lines that we hadn't seen in years because not only were they buried, but they're under plants. So we took the approach 10 years ago to start putting everything on the surface for the very reasons you say. It's cleaner in the long run.
I don't like the busyness of them being on the surface, but it's really a hassle when things are buried and you have a problem.
Well, I vote to approve, or I motion to approve. There's no more discussion. We do have a motion for approval.
Second.
A second. Director Stone, do you have something?
Yeah, I wasn't gonna say anything, but I'm gonna go ahead. Just so Dr. Quillisi kind of has a better understanding and knows that we didn't get sold a bill of goods in the 96 rebuild. That we actually rebuilt a plant over a plant, one half at a time. I think a lot of that stuff didn't get drawn into as-built because they had no clue where it was gonna go until last minute.
No, right. I mean, it wasn't a faulty design or a faulty construction. They wanted to bury things and make it sleeker and they used good products. I mean, they also, once they started digging into the project and building it, they ran into things and rerouted them. So we have a whole load of pictures. And so some areas of some systems, we have pretty good pictures and can figure things out. And in other areas, we don't. And so, again, it's no fault. It's no bad design, bad installation. It's sort of circumstances, method of construction. And unfortunately, when you bury things, they just don't stay sealed and perfect. And a few of them have popped up over the years.
No, I didn't mean sound more critical of whoever did the documentation of the 96 rebuild, but I've had to put in antenna fields for the Air Force. And this involves trenches and multiple coaxial cables anywhere from 1 5/8 inches to 5 or 6 inches in diameter. And once you put all the cables in, fill the trenches back in, you expect it's going to stay just fine forever. And within a couple of years, farmers that in the area, and I'm talking in particular about Nebraska, they're running cattle back on that ground again. And you would never know where that stuff was. You hadn't documented it at the beginning. You're still gonna have problems, at least you can find them. So, yeah, this, not as pretty, but be maintainable.
Yeah, and again, it's not pretty, but the guys will know exactly where it goes. And if something happens, they can find it out and do it quick and fix something.
Director Martinson, was your motion including 12A and B?
Second.
Allison, please take roll.
Director Kintosh. Martinson.
Yeah.
Stone.
Yes.
Clerk Willoughby.
Yes.
Mayor Bird.
Okay, moving on. Item 13, review and discussion of proposed updates to district code regulations. We're talking about ordinance number 74. I think the directors have a chance to review item 13. Any comments on that?
So the way we put this together, there's sort of two sections. One is ordinance 74 revisions. And then the second is district code of regulation revisions. 4 or 5 sections. And so took this to the ordinance committee, and there was some discussion. And I think without sort of, give me if I'm wrong, or it felt like the committee said, hey, let's go to the full board and sort of talk it through before we make any final decisions. So we haven't brought a recommendation specifically, do this, don't do this, make this change, don't make that change. We've really put together and said, look, here's the list of changes. How would you like to proceed as a board? Do you want to have us finalize these and go forward? Do you want, and then bring it back to you for actual approval? Do you want to provide some guidance or some thoughts, send it back to the committee and have the committee chew on it and some alternatives? Or do you want to, say, hey, it's pretty close, make these few changes and bring it back to us for review? So it's really sort of a work in progress. This item and a couple others later in the agenda package. But the first group is sort of board member day of service compensation history questions. And what is a day of service? We haven't had changes to our compensation for board members. I don't have it right in front of me. I thought the last time we changed this was in 2017. 14. So it's been almost 10 years since there's been an adjustment in the compensation rate. Years ago, years and years and years ago, we used to have 2 rates. We used to have a rate for a committee meeting. We used to have a rate for a board. And the committee meetings were half the dollar value of a board meeting. That was just the standard. And over the years, there was some discussion about changing that. And so we went to this day of service designation because there were things that showed up under board member obligations that weren't specifically a board meeting or weren't specifically a committee meeting, whether that was a CASA meeting, whether that was VCTC, or sorry, LAFCO, or any other agency you attended. And so we came up with this designation, which is pretty standard in industry now, of a day of service and a one-time dollar figure for that day of service. Opinions have varied all over the board. I've heard all kinds of discussions from various board members over the years about their thoughts on it. And it really comes down to sort of what is an appropriate compensation for a board member to read this 300 megabyte package, attend a meeting.
600 pages this time.
Sorry. But but what is an appropriate level of compensation for that? Now, some agencies have much more grandiose benefit packages than ours. And that's been a discussion point over the years. Some agencies, have a higher dollar rate. Some of them pay for medical benefits for board members. Some of them even have board member participatory in CalPERS, potentially for, a retirement program. And the opinions and the conversations have varied widely over the years. So I don't want to try and imply that it's one way or the other. Our board has generally said, it's going to be a day of service. It's going to be a compensation rate that you feel as a group reasonably reflects some compensation for the service you provide to the community, and not include sort of some of the other sorts of things that have occurred at other agencies around, even locally.
Is the committee looking for a recommendation from?
Well, I think I would characterize the committee to say, didn't want to jump in and come to a conclusion. Really wanted to open up the discussion for the entire board, to have all members have a chance to sort of, have a discussion and then decide on a direction. So with a little bit of sort of staff perspective, we have seen over the years that the $175 current value of a day of service is been surpassed by some other local agencies. If you feel it's fine for you as a board, it's completely your decision. This is not dictated by state law. There isn't a standard out there that says thou shalt pay no less than this or no more than that. You have the discretion to look at that compensation package and come up with what you feel is an appropriate valuation for the service you provide to the community and to our ratepayers. So it's open. The 175 is a little low compared to other local agencies. We don't offer all the other benefits, but that's just sort of my perspective is what I see other agencies. I see for a similar complexity of agencies and similar sorts of levels of compensation, I see other agencies in the range of anywhere from $200 to $275 as a day of service would roughly be the range of what I see versus your responsibilities and roles versus others if you knock out that upper tier sorts of stuff. But it's entirely up to you. If you want to provide us staff some, hey, go and look at this, or hey, go and compare us to that, or hey, give us, a range of recommendations. If you want to see an option A, B, and C, we'll be happy to bring that back either to the board, or if you want to push that back to the committee. But I think the committee wanted to sort of say, hey, before we trudge into this, let's have a conversation with the board as a whole. So that's the money side of the sort of discussion. The other piece of the compensation is this discussion we've had a couple of times about now the whole situation we have with remote work. With the advent of the technology and COVID and some of the state laws that have been passed, it is technically feasible for us to hold meetings and none of you be here and have a meeting and conduct our business. That's possible technically. The state has stepped in with some new guidance on the Brown Act and said, in order to hold a meeting, we have to have a quorum here. And if you're not here, in order to be a voting member, you have to fall into one of two categories for voting member for remoteness. So the state has said, yeah, you can do some remote work, but they've narrowed the lane a little bit from wide open COVID don't have to be here to serve the public and to serve our constituents. They want a quorum here and limit the number of remote sort of access points. I think I've heard from several of you, and you've said, in discussions on this topic, that the dialogue seems to flow better and the discussion and the deliberation works better if you're here. But I haven't heard that, you've been sort of absolute on thou shalt be here sort of thing. So there's some open sort of discussion about should a day of service, it isn't defined in the Brown Act, only limit this kind of thing. I can see some value. I can see both sides of the equation. Everybody here obviously is a much more robust sort of dialogue between the 7 of you as you deliberate topics and discuss things. It also is an easier communication when you're in the same room versus 7 different TV screens. So I can see the having everybody here. I can also see the case for some allowance for some remote attendance and remote participation on the basis that you all are on the ground in the community. You all are on the ground on topics of relevancy about policy. And so if you're online occasionally, from time to time, is that of value to the constituents that you at least get compensated for that day of service, even if you can't vote under AB 2449, because that's a separate, very narrow definition of the state. But is there some value for you to be present and get paid? Much like if you're a alternate person to VRSD or CSDA or some other group, you go and listen to a meeting, you go and attend, you go read the package, you go and participate in the attendance at a meeting, but you're not a voting member of VRSD, yet you still get a day of service for that, going to that meeting somewhere else. So I see both sides of the equation. Really, I think up to you as a board to decide what you think your participatory sort of structure should be. And then secondly, what you think an appropriate sort of compensation level be. Now, if we want to have a dialogue and you want to move forward on something, that's great. If you say, hey, sounds good, it's a good conversation, can you bring us back a couple of sample sorts of scenarios to consider in more detail at either the board level or committee level, we'll be happy to do that as staff as well. So the second part of this is really a little bit more direct, that we believe there are some word changes that we need to make to our code to provide some clarity on how we apply our code and what we sort of, how the words matter. In a couple of cases, we need to change some words, and in a couple of cases, we need to sort of add some explanation, certain things. But I'll be happy to answer questions. You guys take it away.
Director Martinson.
My general thought on this is it's something we should probably take up in the personnel committee. Maybe get a better idea within that committee, the types of things we want to provide ranges to, perhaps things that we want to address as a change, don't want to address as a change. It just seems like it's kind of general right now to do much of anything.
Well, it is general, but we wanted to sort of say, hey, this is a high level. We're at 30,000 feet. We're not down at the,
I think we could get maybe 10,000 feet. And I think, to your point in general, is right now we've got a board member that's not present. Does he get paid for a day of service? We've got an example right here tonight. So, it is a question that I think is a valid one.
So what's your opinion on that subject?
Whether he should be paid or not?
Yes.
If it were me there, I would say absolutely.
Okay, we have a one for.
I would say in general, if it's somebody that's, online or going to something that's at the direction of the board, there should be some form of compensation, whether it's the full-blown daily amount, or some showed amount, I'm kind of, I think, in this case, I think Mr. whoever might be out there is valuable, even if they can't vote. sad thing is not only can they not vote, they can't comment. Except as a public member when they're out like that. So I can see there's a fine line, and I don't know if there's any legal issues with paying somebody that's not acting in
I'll
an
let
official-
Robert answer that question.
You know, he's not acting in an official capacity right now. He's a member of the public attending a board meeting. You know, that's,
Useful for him having knowledge.
oh, well, sure, and he develops the knowledge for when he is present, so. Yeah, that's a good point.
Legal counsel,
Yeah, I just,
there's no, is there kind of state direction on this or?
yeah, there is state direction on this issue. Health and Safety Code Section 4733 lays out how board member compensation is to be done. And there are key terms within Health and Safety Code Section 4733 that are further explained in the Brown Act. So let me just go through at least a couple of the key sections of Health and Safety Code Section 4733. And this goes to everything that you've been talking about. So this is relevant here. Number one, a board may fix the compensation amount for members on a per meeting basis. So first question is, what is a meeting? Meeting is defined in the Brown Act, and I'll get to that in a second. Number two, compensation is only for, quote, each meeting attended by the member. Okay, so then question is, someone who's attending, not in a member capacity, a member for purposes of the meeting, and therefore for purposes of compensation. I asked the question, I'm not giving an answer at this point in time because you're using the present circumstances as an example. Three, compensation is statutorily limited to no more than $100 for each meeting attended by the member, with the exception of an increase in that amount if the board adopts a greater amount by ordinance. So you've already done that over the years. You're at 175. You can do that again, so long as it's done by ordinance. Four, the compensation is also limited to, quote, each day's service rendered as a member by the request of the board. There you have the issue of a day of service, but then again, rendered as a member. So you have to be a member of the body in a meeting to receive that day's service, which then therefore qualifies for compensation.
This be like attending a conference?
Yes, that's at the request of the board. So let's say they send you to a CASA conference and you attend each day of service, that's a day of service. As a member, you're representing this agency. Compensatory limitations shall not exceed a total of 6 days in any calendar month. So even if you raise your day of service in a meeting as a member, it's only limited to 6 of those meetings. Even if you have 20 meetings in that month, you only get compensation for 6 of those. And that's again by statute. And then finally, member director's activities on any given day are compensable under the code section is a matter to be specified in government's code section 53232. Go to that section and then it refers again to the definition of meeting in the Brown Act. And so a meeting in the Brown Act is when a member attends, quote, to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. Again, that's defining the activities a member in his official capacity in a meeting that is defined by the Brown Act. Okay? And the meeting is defined in the Brown Act as any congregation of, quote, the majority of the members of the legislative body at the same time and location, including teleconferencing locations, as permitted by section 54953. That section was what the general manager referred to as being amended by AB 2499, which is the 2 exceptions to attending the meeting, attending remotely, either for cause or for an emergency purpose. And those are limited in scope, but those amend the ability to attend by teleconference in 54953. So this level of detail, I think, would add it to whatever discussion you would have as a deliberative body about how you would change that.
Director Kentosh, any ideas on your recommendation to the committee?
Well, I kind of like I think people who, board members who, not us, Follow the meeting. More familiar with the topics for the following meetings they attend, so they carry that history with them. Plus, we do talk to the public from time to time. You may ask a question about something that happens at a meeting. So I support the idea of paying people who watch their remote, as long as the law allows that. The other thing was, that we talked about at the committee meeting was, should we give a bump up to our salaries? And I'm a big believer in better to have multiple small bumps than to wait 20 years and have it all at once. Because we get a lot of bad press during that all at once. We just said, let's bring it to the board and see what they think. There's kind of a groundswell that we should bump ours up a little bit. I support it.
Dr. Stone,
Well,
recommendations?
yeah, I think if it goes to the personnel committee or goes to another committee, I think it would be a great help if Robert was there to kind of keep us in the water. Bit of meddling off into. As far as compensation, I've told the story before. I first got on this board in the early 90s. I didn't know you got paid to come to meetings anyway. And if I would do it for nothing, and I would still do it for nothing, what I signed up to do as far as a community service. So I think doing what we get now is fine. That's just my 2 cents.
Director Quillisi?
Yeah, a couple of comments. As Mr. Kwong was reading to us from the statutes there, 2 terms and clauses that sounded a little inconsistent to me. One said you get paid for each meeting. The other one said you get paid for a day of service. Now, these items 13 and 14 were deliberated in the ordinance committee and the personnel committee. We had those meetings back to back. I happened to be on both committees. So I attended 2 meetings, but it was 1 day of service because it was the same day. And that seemed eminently fair to me. I was here for 3 hours instead of 1 hour. I was fine. And like Director Stone, when I was elected 4 years ago, I didn't realize this was a paying job. The third thing is with regard to the remote attendance. There is another thing that can be done under the original Brown Act prior to any amendment by 361 or 2449. And that is, you can attend if you know where you're going to be and the locale where you are attending from and become a part of the public meeting. I just did this on November 15th as a member of the Ojai Planning Commission. I happened to be in Knoxville, Tennessee that day. But before the meeting, the agenda said the meeting is going to be held at City Hall and my location, my daughter's home in Knoxville, Tennessee. Perfectly legal. And I participated as a fully deliberating and voting member of the Planning Commission. So that's another way this can be done. And it certainly was a day of service, but the rate for the Planning Commission is 0, so it didn't really matter a lot. In that case, but that's another thing that can be done.
So the next meeting's not going to be in Tennessee? Is that what we're?
No. That one meeting was in 2 places. And I had to post the agenda for the meeting on the front door of my daughter's house and invite the public in. Well, nobody else in Farragut, Tennessee knew who we were and nobody cared. As far as the compensation, I'm happy to do whatever the board thinks. The CPI says the compounded or not compounded would make the rate about 225. And that's still lower than some of the local districts.
I read that as well. Roughly 30% simple.
Right. Yeah, it's
over the 9 years, okay. So, I would recommend that modest fee adjustment be considered based on the cost of living in that period of time. I think it's appropriate, but I would not want to stand fast on that. I mean, it's my feeling. Ken Tosh mentioned it. As far as remote attendance, I kind of agree also with Director Ken Tosh that there is some value to attending the meeting as a non-voting director, just for the sake of background and knowledge for the meetings that come. You're at least aware of what when Director Ulrich is now been made aware of 2.5, 3 hours of our deliberations, and he's richer for it. Anyway, that's my feelings on this. So you have taken any general knowledge of this, let's take it back to the committee. I would recommend they meet again and consider what we talked about here.
So if I hear correctly, we'll go back to a committee. You've all had the chance to sort of talk, discuss, question, state your kind of personal opinions. We'll craft up a couple of scenario 1, 2, 3, whatever, and have Robert there so we can have a flowing discussion of those 2 or 3 options, and then put some numbers to it based on a couple of different math scales, and then the committee can have a little bit more to chew on. And then eventually, if the recommendation is come back to the board with a specific recommendation, that's what I'm hearing. Okay.
Any other? So there's no motion. We're just.
No, it was just a discussion. We started to sort of wade into the water on this topic, and I think the committee kind of thought that maybe before we kind of moved from talking and deliberating at the committee to get some more broad range discussion from the whole board. So that was the goal of tonight, not to say, let's go get this approved or get that approved, but just sort of hear each other and go from there.
Okay, let's now move on to item 14 for discussion, which is review and discuss the proposed updates to the district personnel policy. This is from the personnel committee as well.
So this kind of followed the same sort of discussion. I heard from several board members over some period of time, and coupled with sort of our discussion at the staff level to management level, it was really time to, in parallel with our class and comp study, take a look at our overall employee handbook. Our employee handbook was prepared years ago. It's been updated a couple of times. The last update was in 2019. Some laws have changed, and it became time to sort of change those sorts of laws and make sure that we were in compliance with those laws. So we had Liebert Cassidy, our HR labor attorney, take our personnel policy, go through it, and recommend some changes to it based on some legal structure issues and their legal sort of opinion. A couple of things for context. Several of you have come to me and said, we want to see exactly what Liebert Cassidy says. So what's before you is really a draft of exactly what Liebert Cassidy wrote. Now, Liebert Cassidy only serves public agency clients. They don't serve private clients. Our primary contact with them is a guy named Danny Yu. He's been with them 10 years. He's a partner. All he does HR, employee relations, labor law, and litigation. So we said, Danny, here's our handbook, which was updated in 2019 by Liebert Cassidy, and said, let's do it again. So that's exactly what's before you. It's rough. There's some text edits. It says city in a couple of places. It's basically their first draft. The goal was to say, here's what the law says. It wasn't to make any recommendations to you as a board to what you should do or could do. It was really to say, what's the law here? So we took it to the committee. And I think the same sort of dialogue happened. Hey, there's a lot of stuff here. Let's go sit down with the board and have a discussion. So that's what's before you tonight, is really to have a discussion about where we are. A couple of things. There are some things in the law that you, the board, have the option to change. There are certain things you can't change. For instance, up until a new law was passed, there was no law that said thou shalt approve bereavement leave of any kind, whether it's paid or unpaid. Our previous standard was 2 days of bereavement. Now there's a state law that says thou shalt, all agencies, all employers shall have 5 unpaid days of bereavement. So we went from no law and board policy that said 2 paid to state law that said 5 unpaid. Now, I wouldn't recommend, if it was up to staff to me, I wouldn't recommend that we have unpaid days of bereavement leave. I think there's an element of, once we take a look at the details of the legalness of what was written, that we then apply some humanity and some grace, respect for people in what we kind of move forward with. But that's your choice. Legal says you have to give 5 unpaid days. You want to give 5 paid, you can give 5 paid. If you want to give 10 paid, you can give 10 paid. You want to give 5 paid and 5 unpaid, you can do that too. So this document was not said, here's the recommendation we recommend. Here's what the law is. Because that's what I heard from a couple of you, a few of you. We want to see exactly what the law says. That's what's in front of you. What I would recommend we do, based on the committee discussion, is that we sit down and have a study session and look at all our benefits and talk about what the legal limit is, what the legal says, and where the board and where the district wants to sort of improve that or change that or make recommendations to that. That's your discretion. One of the other sort of specifics, and I wouldn't recommend we change it, but if we look at benefits, and several of you said you want to look at it top to bottom, is we give 11 holidays. There's nothing in FLSA, the Labor Standards Act, that says thou shalt give vacation days for holidays. Now it's practice. We have 11 days, but we don't give Cesar Chavez Day. We just had Thanksgiving. There are agencies that give the day after Thanksgiving as a vacation day, and some agencies don't. We do. That's at board discretion. I think it's a good thing to have a few days off for holidays of traditional nature for, all of our employees. So if we look at benefits from top to bottom, I think we should start with what the legal laws say. And then you make decisions about where you think we should improve it. I would say most of our benefits are pretty standard. If in looking through our class and comp study, we don't have benefits that are wildly out of tune with other agencies and other appropriate sized companies. But a couple of you have said we want to look at things from top to bottom. So I think really the best plan is to do a study session and say, here's where everything falls. We've asked a series of questions specifically to Danny Hewitt and Cleaver Cassidy to say, hey, go research this topic and tell us what the legal parameters are. I think that's a good thing. I think that's what we should do. We sat down with staff the other day, had the same presentation on this topic. And some of the same questions you had, they had. What's going on with overtime? What's going on with comp time? What's going on with bereavement? Why is it changing? What's going on with FMLA leave? And so we're going to put together a study session for you to say, here's what everything means and here's what everything says. And I think that's a good approach. Going to take a little bit of time to get all those answers back, but I think we should make sure we do it cautiously and make sure you're fully aware of everything and make sure we fully explain where we're doing things. I had a conversation this weekend with someone, and they said the difference between customer service and customer experience. And people talk about good customer service. Well, customer service is really the what. When somebody comes in to file to ask for a permit application or an inspection, that's the what. That's the customer service. And the question is, do we have an environment where we have high quality employees that will help somebody through the what? Here's the application, here's the information. If you do this, I can help you with that. And that's the customer service side. The other piece is the how. How did you provide that service? Did that customer have an experience where you were helpful, you were nice, you were gracious? I think that's the only standard that we want here. And that's the only standard we want for our employees, is to make sure that they're in an environment where they can provide the customer service and the customer expectations of an experience to get things done nicely. Our business has gotten complex. Years ago, we had a customer service database that had a list of APNs and a list of what we charged those customers. And we used our customer service database basically as a billing vehicle to send that information to the county so the tax assessor could send out the tax bills. Over time, our business has gotten more complicated. And we've had to implement a lot more processes to make sure things were handled, are done legal. As we've seen tonight, we need to make sure that we have a good firm foundation in what is legal. And then we make sure that we have a clear understanding of where discretion, what that discretion is. And for our situation earlier tonight on a legal basis, went through where is our interpretation based in legal and what does our code say? Same applies to our personnel policy. What's the law say? Several of you have asked. Now the question is, let's go through a process, explain what is exactly the legal standing and where we should maybe make improvements to that. So the committee started to wander into some of these topics in some discussion and say, whoa, let's get once again this input from the board as a whole as to some of these topics and where you'd like to go and how fast you'd like to proceed. That's really where we think the path forward is, and we'd really look for your thoughts on things you specifically see, questions you have about us to pose to Lieber Cassidy, all of those sorts of things.
You've got your comments?
I think the easiest thing to do, I mean, they're working with this stuff every day, is for staff and the general manager to make recommendations to us, take it to the committee, and then we can check. I'll go up a little bit on that one, down a little bit on that one, but have them make a recommendation to the committee. We come here as a committee, like scratching our heads going, gee, we never thought of this before. That's my suggestion.
In other words, take direction from staff as to what needs to be.
A recommendation, I wouldn't say direction, I'd say recommend, listen to what staff has to say. And we tweak that up or down, depending on what we think.
Alternatives from staff. But I think in this case, the personnel committee probably ought to go through it again. And I have to say, I've had conversations with a couple of employees. And one of the major points of at this point, I would say, is the FMLA law, which I think is reasonably seen as taking benefits away from employees. This business of 5 days unpaid leave for bereavement is just one example. But my question for Mr. Kwong is sort of related. Being a planning commissioner in Ojai, I'm familiar with a lot of housing law and land use and zoning law. And in those cases, in most cases, local jurisdiction is not allowed to be more restrictive than the state law in some places and is required to be less restrictive. Or allowed to be less restrictive, I should say. in other cases, depends on the part of the law you're talking about. And I'm curious about FMLA, specifically dealing with unpaid status, unpaid protective absence. Those are two phrases that are in the law right now. And so does that include FMLA absence or bereavement absence? So are we as a board, for example, allowed to say, the FMLA says 5 days unpaid leave for bereavement? Now, does unpaid leave mean that an employee is in unpaid status? Sounds to me like it does. And that unpaid status phrase flows through a lot of other places in the employee handbook. It has actually serious financial implications for an individual employee if they go from paid to unpaid status. So my first question is, do we have to stick with what FMLA does? I know what Jeff said. He said we have flexibility here, but I want to hear it from the attorney. What can we do? If we decided 5 days was fine, but we wanted to make it not unpaid status, not unpaid protective absence, where the heck, and we decide that bereavement leave is paid status.
You're raising very good questions that are relevant to the personnel handbook. As your general counsel, my recommendation that you seek special HR counsel, which is offered to you by Lieber Cassidy. That your question ought to be obviously taken down by staff and then put forward to the partner at Lieber Cassidy who's in charge of this to answer that one very specifically. I'm not qualified to do that. I'm here as your general counsel with general governmental law experience as well as environmental law experience. So I don't want to venture into an area that's not my specialty. And that's exactly why your general manager has gone out to Lieber Cassidy, that this is the only thing they do is public entity human resources law. That's all they do. So, and I hate to, I don't want to be flippant or anything.
No, that's-
Yeah, but
That's fine.
to give you the best answer, that's the where to go.
Steve, if
There, I would feel a lot better if we had a session with at least one person from Lieber Cassidy and get all these questions out on the table. Because I have this feeling that right now, what the law reads, what the plain language of the law is, at least as it's presented in our packet here, is not to the benefit of the individual employees. And I'd like to know what flexibility the board has to modify that.
Is it possible, Jeff, to arrange a meeting with Lieber?
I think so. I think so.
And make it a day of study session for the entire board?
That's why I think we recommended the study session rather than, because it was, there's a lot of questions and you get way down in the weeds. I mean, and I don't want to overrepresent the law. And I'm going to leave that to Danny.
What happens down in the weeds is where it makes a concrete difference to an individual employee.
Right.
And
That's what I want to be careful about.
And so I'll give you an example, and really, I think the best approach is a study session with all the benefits and how they all interrelate and where the flexibility is and why and how and what. You know, we go back to the bereavement leave. There are situations where someone, you know, has a situation on bereavement leave where 2 days paid may be okay. Then there may be time, depending upon the circumstances and the person and the family situation, where 5 days is nowhere near enough time for someone to deal with the tragedy they have to deal with and get their mind around coming back to work and being safe. And so we have to pick a number. We have to put something in writing. And then we have to have some room to say, apply some humanity to it. It's been applied a couple of times here at the district in my 12 years here. And I can tell you, the 2 days may or may not have been okay in one situation, and the 5 days wasn't even close in another by a long shot. And so no matter what we pick, we have to make sure it's legal. We have to make sure whatever we do is based in some sort of board action. And then we have to apply some humanity to it. I will say, when you start talking about FMLA, you get way down in some very significant court cases about how it's applied. And FMLA leave and cafeteria plan money and overtime rates and all those things are all twisted around each other. And so before we make some flippant, hey, let's just adopt this, I think the study session is the best way to do it. Because then you know where you are and you know what you can do and you know what you can't do. And then we can come up with some recommendations from staff and say, here's where we think. One of the issues is overtime. We're under the federal standard, which is FLSA, which says you don't get paid overtime until you're over 40 working hours in a week. Doesn't say anything about over 8 in a day. Doesn't say anything about anything else. It just says over 40 in a week. You get time and a half.
Does it define specifically what working hours are?
Yes, it does. Yes, it does. And so when we just had a week, for instance, let's use Thanksgiving week. Thanksgiving Day and the day after Thanksgiving are vacation days paid by the district. Under FLSA, they're not working days.
Holiday days.
Holiday days, not working hour days. And so if somebody worked Monday, Tuesday, Wednesday, 8 hours a day, 3 days in a week, and then worked Thursday and Friday, or got paid Thursday and Friday for the holiday, and then came into work on Saturday, they haven't hit 40 hours yet because Thursday and Friday don't count as working days. I don't think that's sort of, appropriate. I think there are some ways where we as a district can say, wait a minute, if you're doing something that is a district dedicated day, I think it ought to count as a working day. Well,
Jeff, are those subjects coming up at the committee meetings?
yes. Yes, these all came up to committee meeting.
The committee didn't want,
The committee didn't want to they didn't say, we don't want to make a decision. They said, hey, we're wandering into some territory where we really want to have the whole board have some opinions on this. And so I think the approach was to say, before we go too far with the committee, let's go talk to the whole board. Let's tell them what we're doing. Let's set up a study session. We can figure out how to schedule the study session with Danny here after we've given him some topics to research and be prepared to answer in detail. And then go through the process. Let's trust the process. Let's trust, our experts. Let's go slow. Let's make sure that it's, well thought out.
so for our discussion today, would the board like to recommend have a study? How would you word that?
I would say a study session and we bring Liebert Cassidy here.
Study session with Liebert Cassidy, getting everything out, answered, clarification.
Chairman
Laura?
Berg,
My sense of this is, tonight we spent 20 minutes just talking about random topics that interest or important. We didn't make any progress. So I'm thinking around these committee meetings, which I think is the right way to do it, is that we first have a committee meeting with the board, go through the policy, find out where our questions are, define those questions, write them out, list them. Then have a second meeting where we bring in the experts to help us resolve those. We don't spend a lot of time just going through random stuff.
He's suggesting a committee meeting before the Liebert Cassidy study session.
I think that's a good recommendation is let's refine sort of the questions down to, a list of questions, whether that's 1 or 5 or 10 or 20. Hey, what does this mean and how is this applied? And where's our discretion in this topic or that topic? I think those are very valid approaches.
That would give your HR council time to put a robust answer together.
I think that's actually a good suggestion that we kind of fine tune the points that need to be studied. Just go in there with 200 pages of general information.
In the end, we may want to do all 200 pages, but at least we don't want to spend
We'll have looked at it.
12 hours. Anyway, I think. Any other?
Chairman Burke, before you make a recommendation, I have speaker cards for this item.
Yes, I almost forgot.
But it's up to you. I think we have virtual attendees that may have not been able to submit speaker cards. So I don't know if you want to solicit any feedback from them first before the ones that are physically here or the opposite. It's up to you.
Let's go with the physical attendees and then we'll go.
Excited.
Correct. Yes. And Lori, are you item 14 also this item?
Actually, I wanted to be a 5 or whatever at the beginning, so I kind of missed it. But I will,
Do you need 14 or do you want to?
I'll do 15.
15?
Oh.
Okay.
You want to wait a moment till we get to?
Oh, no, she didn't put a number on the top, so I didn't know which one she was speaking on. So I want to make sure I have all of them.
Yeah.
So I have Yan for item 14.
Hello, I think you all know me, but I'll state it again for the record. My name is Jan Steenberg. I am the Assistant Operations Manager. I've worked there for 30+ years. As you can see, most of the district's employees are here tonight because there's a general concern with regards to the employee handbook review and current benefit changes. LCW did a review of the employee handbook, which was brought to the Personnel Committee earlier this month for review. In my opinion, this review was very poorly done. There was many mistakes and omissions throughout the process. Proposed changes to the handbook, it was embarrassing. Any change to the employee handbook should clearly state what the current policy is, what does the law require, and what are the proposed policy changes. The employee handbook should also be written in a plain language for easy reading and understanding. And a lot of talk about FMLA amongst all the employees and how the district has interpreted and applied the law. Management had chosen to take away cafeteria cashback money from 4 employees so far while they were on extended leave, surgery, or having babies. These 5 employees have specifically asked HR for this law and it has gone ignored. I've done extensive research myself and cannot find anything that forces the district to take the action that they have. At one point, I asked the HR department to provide me with an answer, and this is the response. The CAEDD website is a good resource, as well as the U.S. Department of Labor website. That's insulting. I have now learned that management has reversed course and written a letter to the affected individuals stating that they would receive the money that was withheld. I'd still like to see the law that forced the district to take the action that they did. And I think the employees affected is owed a public apology. Thank you.
Thank you, Jan. Do you have another?
We do. So I have Liz Dubrin.
Liz.
Good evening. My name is Liz. I've been the project manager for the district since 2016. Aligning with new laws and regulations is the primary reason for updating an employee handbook. That is what brings us here to this agenda item this evening. I stand up here requesting that as you update the handbook to be compliant with the law, that you do not use that time to reduce employee benefits. This draft as it is presented reduces benefits while failing to clarify other gray areas such as paid versus unpaid leave. The purpose of new laws is to protect employees from egregious employers. These laws are a minimum intended to be a floor, not a ceiling, and anything less is illegal. I've always felt as though the district cares for its employees and their families. And in return, the district has 18 employees that care about their job. This was especially evident earlier this year during the emergency spill response, which required all hands on deck, and all hands were immediately available. That's just one example. This included early mornings, late nights, weekends by all staff, treatment plant collections, and admin. I ask that the board continue to encourage and provide an environment and culture of care and concern for its employees. Please do not let this district become a training ground with an ever open operator and training position, but rather let it continue to be a place where employees develop their skills and careers are made. I ask that the board look at each section with a proposed revision and evaluate the current handbook rules and the law to then determine how to proceed. Last, I want to thank the board and management for the workplace culture that I've experienced in my time here. I trust that although the process may take time, including additional committee meetings and study sessions, that ultimately we will end up with a product that will reflect the intent of the board. The district will continue to be a supportive and positive environment. Thank you.
And then, I don't know if you want to see if there's any virtually that wants to speak on this item. I don't have speaker cards from virtual attendees.
So are there any virtual attendees that would like to speak on item 14 on the agenda?
Raise your hand.
Yes, please speak to us.
Everybody's on mute, so they got on mute if they want to.
Can they raise a hand without muting? To be recognized.
We'll give them a period of time to adjustments.
I have speaker cards for item 15 when we move.
Okay. Virtual attendees want to address item 14. We'll move on to item 15.
So just to, so sort of close out 14. So we're going to go back to the committee. We're going to, as Lowell said, unless there's any modification, we'll go back to the committee, dig into each of these sections, come up with specific questions, and then pose those questions to Lieber Cassidy, and then schedule a follow-up board study session with Lieber Cassidy, and using those questions as a starting point for dialogue and discussion.
And both the committee meeting and the subsequent board meeting will be open, and anyone who's available to come to them.
Absolutely.
Maybe we ought to we had the two committee meetings that dealt with 13 and 14 were at 4 and 5 o'clock.
So
I recall, so maybe we should have them later outside of normal working hours so that anyone who wishes to attend can do so. But my personal feeling is we need to go through this time paragraph by paragraph, understand in more detail what the changes are, and make sure that we have not taken the district from being the family-oriented organization that I have always considered it to be, to something that is more restrictive or less friendly or whatever within the confines of the law. Anything that we can do to stay as close to that feeling and that organization of dealing with employees as we can within the law.
So in our practice, going back a long time, and it's just sort of a practice. It's not a adopted policy, but it's a practice that we moved our personnel committee meetings to non-working hours for specifically that reason, so that employees that wanted to attend personnel committee meetings could and not take time off of work from working responsibilities and come. The other half of that was that we would pay them for that because it was a district function. So we would continue that practice, that we would schedule the personnel committee meeting at 5 o'clock or something. And then anybody who attended, we would pay. Because that was sort of the practice that we had followed to make the meetings available to the employees, but not sort of make it involves your work environment. You should have to do it on your own time, sort of thing. So that's the practice that we follow. And I think that we would follow that going forward. So we would schedule a personnel committee meeting at 5 o'clock.
We'll do it that way.
And so that's been sort of the genesis and the practice of the district as long as I've been here.
Really,
Good idea.
I would like to add as a suggestion. I read the revisions or skimmed over the revisions to the personnel ordinance, whatever it is. I didn't notice that it was affecting people in a negative way. So I would suggest as a guiding principle that going forward that we with whatever we come up with doesn't take away net benefits.
Well, I think we can take the legal writing that was done and sort of put that in sort of plain language of what's that mean. There's lots that's been put in there specifically because of lawyer speak. One of the sort of style preferences of employee handbooks is you make them very long and almost rewrite the law into the employee handbook so that the whole law is in the handbook. Or two, you write the handbook very simple and reference these outside laws, because rather than replacing them or rewriting them, you let the reference to that law be the connecting point. It's just sort of a style and preference. Liebert Cassidy has decided to write it the way they've decided to write it. And I said, if we go through each of these sections, I think it's appropriate to say, here's the benefit, here's the benefit. Here's what the law says. Here's where we are. Here's where we think we ought to go. And here's what your discretion is to move and go up with those on a section by section basis. So I think we can do that.
I'm not here on a day-to-day basis to people that got up and gave discussions about what they were interested in. Obviously, something happened, some details. I don't have a clue what they were talking about. Often I'm dense, so that could be it, but if we're going to have these committee discussions, I think it would be useful for people such as these come in and offer the details around what it is that they were concerned about, so that we have some idea, at least I have some idea what I'm trying to address. Because I have no idea what I'm trying to address right now, based on those. I know there's a problem. I don't know really what it is. So if we could, because I think it's very worthwhile when them, they're the ones that are being affected by these policies, not me. I think it's really good if we can see some of the details of, someone said, how these are affecting employees, and specific examples are good. And maybe they don't want to divulge, private information. And so maybe there's a way to put it as a generality or a hypothetical or whatever. But I know these things are, my son's been going through this FMLA stuff for the last 6 months. So I understand the nightmare that can be. So that's just one of many policies that, anyway, that would help me get a better idea of what to address.
Yeah, it's really worth the effort so we can get it right.
Sure. Yeah, can I just say one more thing? Lynn is unmuted now and she wants to speak, I guess. So,
Oh, good.
so Lynn, if you can hear us, go ahead.
Yeah, I can hear you. If you can hear me,
You can.
I might give you a little insight to this. I'd like to start out by saying that last November 22, one of our employees whose wife was having a baby wanted to use his sick leave or paternity leave to help out his family. I was told by Allison that I had to deduct his optional benefit money from his paychecks, as the district was only responsible for paying his health premiums. I said, where does it say that in the law or the employee handbook that you're allowed to do that, as we have never taken employee benefits away in the past? And this employee had already been off twice before. So I sent both her and Jeff an email asking for specific law codes and from the employee handbook, where does it say that you can do that? They both ignored my email. I told Allison at that time I wasn't going to deduct his benefits because she couldn't prove any of it to me, that she was allowed to do that. So after that happened, she told me that she didn't need to recite the law to me, and I was going to do it because she told me to. Then I received a threatening letter on my chair not to talk to employees about their benefits, etc. Now remember, I'm a 22-year employee, I was. So I kind of know history and how things played with the employees. So in no way, after the next month, I had to have surgery. And she did the same thing to me, took my optional benefit money away on my current payroll that I had even been there a few days. So the other 3 people that she took the money from, she did theirs on the following payroll. She did mine on the current, which I totally feel that was a punitive action on her part. Also, in no way was FMLA optional. We were all made to sign the paperwork. even though all 4 of us had enough sick time to cover any absence we had. She could never show any proof that she could take our benefit money away and didn't care that some of these employees counted on their money, including myself. I also want to let the board know that I'm also concerned about the current management team. As I stated, I was a 22-year employee who thought I would be able to finish out my career at the district, but felt that I was forced out due to the activities and the decisions that were being made by management. The treatment of staff and myself and the environment for the employees by both the general manager and the administrative officer has become very hostile, demeaning, and unsupported. No teamwork, period. I just couldn't take it anymore and I had to leave. I gave them my notice that I was leaving. Neither one of them said 2 words to me at all after being there 22 years. I never missed one payroll in 22 years. I went in sick. I planned every vacation I had around the district because I cared that much for the people that work there. I'd come in my pajamas, bronchitis, whatever, to get payroll done. And that's how I was treated at the end. Please do not, I don't want you guys to delay any salaries or any survey that you're being done between the employees and the board because of whatever reason that you might hear tonight. Because really, you need to know the employee's perspective before more employees like me leave. I wasn't ready to retire. I wasn't ready to leave. I just couldn't do it anymore. No teamwork, nothing, no support. It was just awful. And you can't work like that every day. And then when Jeff's saying about customer service, they don't even allow customers to come in our office anymore. We make them say you have to do everything online. We always did great customer service, always. We never had problems with our constituents coming in. When did this start happening? Well, I'll let you know when this happened 3 years ago. All of a sudden, there's no camaraderie. There's no anything. You do what you're told. No team, no nothing. I even offered to come in and do payroll the last time so they wouldn't have a problem doing it. They both blew me off. Didn't even answer me about me coming in. It's a terrible way to treat employees, especially employees, for any employee, but an employee who's been there for over 20 years and that's how you treat people. It's disgusting. It was what it is. And Jeff used to care about the employees. He did. He doesn't anymore, but he used to. And that's when that started too. He used to care about everybody. Now it's like, what do you know? Who are you talking to? It's not the way to be. Environment. And we all got along. We were great together. Not anymore though. If you're listening to, just remember, you need to know the employee perspective. You're hearing. And this is from an employee who's been there, was there 22 years. I loved my job. Come into the parking lot and you're just like, I can't do this anymore. I can't do this anymore. That's shameful. Shameful. For listening. Thank you.
Thank you, Lynn. Did we have any other?
I don't think that there's anybody else.
So staff has direction from the board.
Mhm.
And, let us know how it progresses with
So
you.
we'll go back to committee and we'll pose questions and then we'll have the experts answer those questions. And then come to the board with, a study session with Libert Cassidy answering specific questions and go from there.
And did we agree that possibly we'll have attendees from the staff, employees,
Anytime,
and speak on?
whatever they want to.
It's all right.
Absolutely.
All right, thank you. With that, let's move to item 15. Employee satisfaction survey. Also for discussion.
Yeah, I guess I could probably kick this off since this is something that I wanted brought to the board to look at. I think this is really important. In all the time that I've been at this district, I have never seen this. Never. I want to get to the bottom of what's going on here. I want to know if it's truly management to deal with that, or if it's just people are just upset with what's happening. I don't think that's the case. I would like the board to sit down, come up with a survey the employees can fill out. It can all be anonymous, their names on it. It's information that can come back to us. I think it'll be a valuable tool to bring back to this session. This needs to stop. This to me is for 24 years to make employees happy here. I'm not going to sit and watch it. It can't happen. So,
Which committee would handle the employee survey?
you know, it could be the personnel committee or it could be the executive committee.
It's important.
Yeah, let's do that. Let's have the executive committee meet and we'll come up with an employee satisfaction survey. That has some merit, has some value.
No, I sent you a sample. Another district.
You know, I might have. I will look and take a look at it and see.
Okay, I sent you a sample. At Monterey Oaks Water, we do a employee survey annually. It's confidential, and we just do it just to make sure keep. When these things get ahead of you, it's too late. You want to your finger on the pulse very well, you know, on a daily basis. So we just do it as a matter of routine. It's informative. So, and we've had, you know, a couple of our top employees speaking. So I think I've got my attention anyway.
I agree.
I think as a survey, sometimes the problem with surveys is questions you ask maybe aren't the ones the employees want to answer. You know what I mean? So
I would think they could certainly add anything they wanted
that's what I was
in
getting
addition to what was on there.
if we send out a survey like this, the employee could be able to return either as part of the survey, separate note or letter, where they want to do it anonymously to that committee, the one we define.
The executive.
Those things can be considered as part of that
Stone, right?
survey.
Yeah, okay. So if you
Remember, years ago, we took a blind survey in our group. The group was small enough. The person who was receiving the benefit of the survey knew exactly who everybody was, you know. And he didn't like a lot of it, and people heard about it on their appraisals. So I don't want that to happen here. It's got to be anonymous enough and broad enough that these kind of issues that have come up tonight can be, the board can be made aware of those things.
Let's see, I think we had a speaker card on this one, didn't we?
Two.
Ms. Lori.
Yan.
Oh, yeah, okay.
Sure.
Following Yan, we'll have Lori.
My short and sweet.
I wouldn't mind, sorry, the idea of the personnel and the executive committee building a survey. I don't know how many people are on the XCOM. I don't.
there's 3 on each committee, and we have to be careful to get 5 of us in the same room.
Or it becomes a board meeting.
It's a board meeting. 4 of us in the same room, it becomes
Yeah,
board
the
meeting.
Brown Act. Okay.
So we can do it in separate meetings. We could do personnel committee, we could do executive committee, but we have to be careful how we do those.
Unless we schedule it as a board.
Unless we schedule as a regular board meeting, and in any case, we invite the public. He's
Okay.
here to comment.
The gravity of the subject matter and concern of multiple, maybe better to just bring it right to the full.
Could have a special board meeting.
And then I think that just one question here. If Director Kantosh has a sample, that really ought to be part of the record, the administrative record here, then given to every member of the, so everyone sees the same thing that Mr. Stone sees and you see. Director Stone and Director Kintosh. Anything that you develop or that should be shared amongst all the board.
Good thing to have.
Are you suggesting that subject come back as a study session?
Yeah, that would be another way of doing this. Because again, I'm hearing from multiple people that they want multiple committees. Then you have a serial meeting situation. You can have overlapping directors of each committee. You're basically making the decision of the board and committee. That's what I'm trying to
Not
avoid.
a good thing, yeah.
So might as well just have it come right back to you as a board.
So maybe we should propose to staff to create a study session on the subject for the board, which could be a special meeting.
Yes. It'll be a special meeting.
Is that the?
I agree. I agree.
So that's our recommendation.
Now, the one thing, I don't think that's, it's a small enough board, small enough group. I think that's the right way to do it. What concerns me is if it's a public meeting and some employee is put forward some sort of a note that we review, that, whatever that issue, public,
It's a public.
as in Ojai public. I don't know that the employees are going to be as willing to be as open about that, knowing that that could happen. Or not. I just don't, I don't know if I have a.
How else it could be done? I don't know how else it could be done and not get some
That's
results.
the problem with the Brown Act. It can't get around it. That's it. Unless we keep it small.
I thought I heard that the employee satisfaction survey would be.
Well, it could, yeah, it could be. But again, I just don't know if a person, is necessarily willing to throw even anonymous out into the Ojai Ventura versus just keeping it in within family, so to speak. I'm not sure I even have a valid concern, but you understand what I mean.
I hear the consternation over the Brown Act, but this is a matter of concern. You're a public agency. You're dealing with public employees. And this is a public.
The public's business in public.
Exactly. This is how you're paying your employees, your civil servants, your public servants. So, yeah, there's no closed session for this type. And I think the anonymous aspect of it can be, upheld. And there could be, ample pages with nothing but lines on them to allow anyone to put whatever else they want to put on there.
Let's give Yan the floor.
Yeah.
Okay, it's just a short statement, so I want to emphasize that it's important that this employee satisfaction survey gets conducted as soon as possible. And I don't believe that there's any correlation between the CPS, HR, consulting, classification, and salary survey that's currently being done has anything to do with it. And so I believe this should be done now. And I also believe that it should be extended to the 4 previous recently retired employees. Lynn, Lori, Tom, and Mark.
Thank you, Yan.
My last working day, paid day was November 10, but I would certainly like to be included in the survey.
Noted. Okay. Let's summarize what we just are recommending to staff. We want to have a study session by the board on the subject of employee satisfaction survey and maybe study one done by another organization.
You too.
And so maybe staff, if you can kind of schedule that. Get the boards.
Get the 2 samples as part of the packet.
And get the board together and see who can attend on what dates. There's no reason to delay. I would say that the committee, the names on the committees will be changing after the next December meeting because we have election of officers.
Oh, that's true. That's right.
So there may be some value in starting in January. Because we'll
We
have.
should start next week.
We can start next week.
Oh,
Wait. If this is,
Okay, sorry.
it's a meeting of the whole board, it won't
The
change.
committees will be
Right.
changing, but the board will not be changing. So we could schedule this as soon as the board can meet on.
Let's do that.
Sooner the better.
Um, And are there any other comments regarding employee satisfaction survey?
It's gonna be a difficult process, but we have to get charged in ahead. It happens.
We have to do it.
We do have a closed session item 16 that I would like to move it to become item 23 in the agenda so that we don't have
The others up.
sitting here waiting, going through the closed session outside, waiting for us to finish. So let's continue now with items 17 through 22, which are information items. Are there any comments regarding any of the information items? 17 through 22.
No questions.
Okay, item 23, board member and general manager comment. Are there any board member comments? For items that may not be on the. General manager, item 23, general manager comments.
Yeah, just a couple of sort of comments. Things are still slow on the whole retail or the realtor sales. We have 2 PSL inspections this week. Kind of indicating that, things are still kind of really slow on the whole real estate transaction.
Loans are expensive right now.
Yeah, they are. We talked about DFA closing. That'll have a financial impact on us. But we'll work through that in the next budget cycle and kind of come up with revenue projections that exclude that extra cushion. We had, an appeal today on an ADU. We're gonna have a closed session. We've got a couple of other situations that are brewing. The Chantico Inn, on Ojai Avenue had a third spill in recent times. We're working with legal counsel on appropriate next steps. We've issued them 2 NOVs, notice of violations. Or assisting with, how we ratchet up the process with them. And then kind of just a LAFCO situation. So anytime we have a septic sewer vacant lot added to our districts, they first have to go through LAFCO. Not allowed to extend service to any property because they want us to. Have to go through a LAFCO process that sort of spans our city limit line, our district boundary to include that property. Every one of these septic to sewer that we're talking about out on East Ojai Avenue and the Ojai Lumber area, they have to go through a LAFCO process. They have to go through a formal process. We've had a situation arise of recent where property went through LAFCO. Was almost to the end, but the County of Ventura Planning Division had some violations on that property. Well, LAFCO and the county planning people talked, and LAFCO decided to withhold final approval of that annexation. So just this week, that annexation period under LAFCO's processing time, the timeline expired. And so we were forced to write a letter to the property owner that said, hey, you're not LAFCO approved because LAFCO and county planning were talking about the situation. Our hands are tied because we're not legally allowed to extend service if LAFCO doesn't do their final approvals. And LAFCO was talking to county planning about an on-site violation. And so we get embroiled in these sort of extended conversations on properties. We only had one course of action that we could follow, but we're going to have a real happy property owner because they're going to have to start the LAFCO process all over. And there's significant story in processing, but we get into those situations and unfortunately we do what we can, but we also have limitations on our powers as a sanitary district what we can and cannot approve. So that's all I have.
Good, thank you, Jeff. I think we should take a momentary, just a break here for a few minutes to clear the boardroom so we can go into closed session. Thank you for attending. It's been a while since I've seen some of you. Yeah. Yes.
I have to keep my word out to you.
So we're going to go to closed session. We need to close out all of the remote attendees.
Have to close out Mr. Ulrich as well.
Yes.
Because he's not
A legal.
in attendance.
Compensation issue already. I'll just go ahead and make a statement for the record here.
We're still closing out. So
Yeah, but no, I'm just gonna read the agenda title here. Read it. It's the intention of the Ojai Valley Sanitary District Board of Directors to meet in closed session conference with legal counsel on an existing litigation matter pursuant to Government Code Section 54956.9, subdivision A, in the matter of Richard Vane and Kimberly McLinn et al. Versus the Ojai Valley Sanitary District, Ventura County Superior Court, case number 2023 CUBT 011481.
Do I need to state the time?
Yeah, we're going into closed session. I have 9 p.m., excuse me.
Okay, we're going into closed session here at item 16 and
we'll have a couple people.
session at 9:20 p.m. with nothing to report. And are there any further comments from our manager?
Yeah, so one of the things I forgot in my general manager comments, I had it on my notes and I slipped my mind. At next board meeting, December, our auditor is going to prepare his give a verbal report on the audit. We got some dings this year. We've had 11 years of clean reports. This year we got some dings. We need to make some improvements.
What's the worst thing?
None of it's fraud, none of it's theft, none of it's embezzlement. It's not stealing of money. What it is it's accounting process. Two things came up, and there's about three instances. One is when a contractor does work for us in one fiscal year, that work accrues in that year. So they do work in April or May. And then they send us a bill. They don't, believe it or not, contractors on even big bills don't send us the bill the next day. Sometimes we have to beg for the invoice. Where's the invoice? Where's the invoice? Where's the invoice? We had a situation where we had two invoices that occurred for work in last fiscal year. They submitted the invoice. We paid the invoice, all per contract, all per scope of work, no dispute, no any of that. But the work occurred in one fiscal year and we paid the bill in another fiscal year, but we didn't in an accounting way make that connection across the fiscal year boundary. So the auditor says, well, you're paying it in this fiscal year. You accrued it there and you make no note in your audit as to this work occurred here and it should have been noted that it occurred here. We made a mistake. So now we get a big black mark on our audit for not accruing and accounting for the dollars in the year that which it occurred. We're going to get a ding on that. Second situation is, and we have a couple of these, is where same sort of situation where we didn't send a bill to Casitas for 6 months. And so the revenue, the bill, the receivable was in last fiscal year.
Did that 6 months overlap of fiscal boundary?
Yes.
No, it didn't, but it was enough of a revenue non-reporting for it to be an issue.
We didn't report, it was a dollar amount.
6 months of one fiscal year.
So we incurred the revenue in 1 year, but we didn't bill for it. And so when the auditor caught we didn't bill for it, the dollar figure for that unreported revenue was of such significant nature that he's got to say, hey, you didn't have a $5 sort of bust here. You had a $50,000 bust here. So we're going to get a series of 3 or 4 dings from our auditor about those sorts of things. We need to tighten up our accounting process. We need to tighten up our sort of sequencing of bills. And we have some programs in place to do that. Specifically, when a bill comes in, we're going to start coding it into our accounting system.
If those things on the auditor's report, they don't really cause any harm to the district.
No, because all of it was per our process, like the contractor invoice. We have a signed contract to do the work. The contractor did the work. The work was approved by our project managers and project engineers. It was appropriate work. It was just how you account for the dollars. We didn't have it in the right here and actually make the notes ourselves. The auditor caught it. When the auditor catches it,
Must be years.
get dinged. I hear from him in December, and I wanted you to hear it from me rather than from him. But those are the things. There's about 3 or 4 of them. None of it is fraud or misplacement of money. It's just how we did our audit. How we
Significant accounting wide, but they're not material to the operation.
Correct.
Thanks for giving us the advance. Okay,
Incoming.
we have completed our agenda for our regular board meeting, so let's call the bell at 9:25 PM. Thank you.
Thank you very much.